What happens when the U.S. government tells thousands of immigrants they may qualify for a visa, but then says it doesn't matter because of the country they come from? A federal judge in New York has now delivered a major answer, and the ruling could have immediate consequences for families, workers, and visa applicants across 75 countries. On Friday, U.S. District Judge Jeannette Vargas struck down the Trump administration policy that froze immigrant visa processing for nationals of 75 countries. The policy had been announced by the State Department in January and was tied to concerns that applicants from those countries could become dependent on public benefits. But Judge Vargas ruled that the policy went beyond what Secretary of State Marco Rubio was legally allowed to do. And this is where the case gets especially important. According to the ruling, applicants could go through the normal visa process, provide the required information, and even be found otherwise eligible. Yet if they came from one of the 75 designated countries, the outcome could still be the same. Their immigrant visa would be refused. Judge Vargas said that system was fundamentally at odds with the immigration process created by Congress. In a 61-page decision, she ruled that the policy was contrary to law and exceeded Rubio's statutory authority. She also took direct aim at the administration's legal reasoning, describing it as an exercise in Orwellian logic. That language is likely to become one of the most talked about parts of this ruling. The administration argued that consular officers were still making the actual visa decisions because they formally entered the refusals. But the judge said that argument ignored the reality of what was happening. If the government had already instructed officers that certain applicants had to be refused because of nationality, then the individual evaluation Congress intended those officers to perform had effectively been taken away. The policy affected a huge geographic range, spanning parts of Africa, Latin America, the Caribbean, Eastern Europe, South Asia, Southeast Asia, and the Middle East. Countries named in reporting on the policy included Afghanistan, Iran, Russia, Somalia, Brazil, Pakistan, Nigeria, Nepal, and dozens of others. Importantly, this was about immigrant visas, the visas used by people seeking to permanently move to the United States, not the entire universe of temporary visitor, student, or work visas. The administration's stated concern was the so-called public charge issue, whether an immigrant might become dependent on government benefits. But the lawsuit challenging the policy argued that the government had gone far beyond an individual assessment and instead imposed a sweeping nationality-based barrier. The plaintiffs included immigration advocacy organizations, prospective immigrants, and U.S. citizens trying to bring family members to America. Now, Judge Vargas's decision does not mean that every applicant from the 75 countries automatically gets a visa. That is a critical distinction. Applicants can still be denied for other legitimate legal reasons. What the ruling does is eliminate refusals based solely on the 75-country freeze and requires affected cases to be reconsidered under the normal legal framework. But here's the bigger picture. This ruling also shows a major legal divide between a president's broad authority over immigration policy and the specific limits Congress places on individual government officials. Judge Vargas distinguished this case from the Supreme Court's 2018 decision upholding Trump's first-term travel ban. That earlier case centered on presidential authority over entry into the United States. This case focused on whether the Secretary of State could use an internal State Department policy to override the individualized immigrant visa process established by federal law. The decision is already a significant setback for one of the Trump administration's efforts to tighten legal immigration, and it could have deeply personal consequences. For months, families may have been separated by a process in which an otherwise qualified applicant could not move forward simply because their nationality appeared on a government list. What happens next remains the key question. The government could accept the ruling, change its policy, or seek further legal action. As of the latest reporting, the State Department had not immediately provided a public response to the decision, so this story may not be over yet. For now, though, The message from the federal court is clear. Immigration officials cannot simply replace an individualized legal process with a predetermined outcome that Congress did not authorize. For thousands of people affected by the 75-country policy, that could reopen a path that had suddenly been closed. And the larger fight over how far the Trump administration can go in reshaping America's legal immigration system is clearly far from finished. If you found this update helpful, don't forget to like the video, subscribe to PrimeWire, and turn on notifications so you never miss the latest news. Thanks for watching.